Good evening and welcome to Transition Talks Tuesdays. This is presented in partnership with Sauk Prairie School District, the wonderful Liz Kennedy. We are thankful to the Interpreters Co-op as well as the Wisconsin Integrated Transition Planning Project, who are providing for the simultaneous interpretation into Spanish. Tonight, I'm excited because we have a returning person who has done the talk on supported decision-making and guardianship a number of times for me in the past. So what that means is I'm going to turn it over to Tami, and I'm going to go catch dinner at like McDonald's or something down the road because she knows the stuff. So I'm out of here. Nice to see you all again. No, trust, I'll watch the chat, Tami. I'll hang out. But glad you are all here. And Tami, do you want to go ahead?
Sure. My name is Tami Jackson, and I'm the Public Policy and Legislative Liaison for the Wisconsin Board for People with Developmental Disabilities. I was one of the people instrumental in passing the supported decision-making law we have, as well as guardianship training requirements, and I'm currently working with a group of folks across the state, attorneys and a judge, who are really interested in improving how we think about making decisions about whether guardianship is the right choice or something else. Tonight's presentation, we are going to discuss a range of options, and I will likely spend more of my time on the front end than the details of how to do supported decision making. You will get this presentation to refer back to, so if you miss something, do not worry. And I see we have about 4 people on. Has anybody is anybody currently a guardian now? And it's okay if you are, I just want to know because it changes, like I want to add a little bit for those folks if you've already gone to court to obtain a guardianship. Looks like no. Okay.
And, yeah, and I'm not seeing anything in the chat either, so I think you're free to go ahead.
Okay, I'm going to share my screen, and if you give me a moment, I always have to relearn every single time. I think that's what I want. Okay.
Yes.
So all of you are in the thick of it. You are in transition. That time when you're being asked to do a lot of really complicated things that have a lot of steps and a lot of requirements in a wide variety of areas in your person's life. And oftentimes, one of the things that is added to that pile is, does your person need help making decisions? And then very often, there's one option presented, guardianship first. Today, we're going to talk about some of the other options and some of the reasons what things to think about before you do go and get a guardianship. Now, important, I always frame the presentation like this. Under the law, Wisconsin presumes you are able to make your own decisions. And they say adult. Adult means age 18. Some of us turned 18 and we were fabulous decision makers. Others of us were not. We won't ask you to divulge what decisions you made that you would do differently now. But 18 is that magic bright white line in the state statutes that says this is where we decide you're an adult. And we presume you are able to make your own decisions. Decision making isn't an innate ability. You learn it. And you learn decision making by making mistakes and learning from those. And everybody needs the opportunity to have different experiences and make their own decisions and learn from those decisions. And there's a lot of ways people do that before age 18. Some of them are simple. Nobody picks out what clothes I'm going to wear at this point in my life. That was not true when I was a baby, but it is true now. I've gotten better at it. I make my own decisions about all sorts of things in my life, and so do you. The way what we're interested in, how we spend our free time, who we want to be around or not around. And for most of us, we have had practice in making increasing amounts of decisions. I say this because this is true for all people, like including people with disabilities and kids with disabilities. Although I will put a little asterisk, many people with disabilities haven't had the variety of experiences with making decisions as able-bodied people, because even though the law presumes that all people are competent to make decisions if they're over 18, culturally, we assume the opposite often for people with disabilities. Also true of older adults and others. So what is it about decision-making that's so important? Determining the kind of life you want to have, the kind of future you want to have in small and large ways is fundamental to who we are as people. Free will, right? Free will implies that you get to make a choice, self-determination. What kind of life do I want to live? Somebody else is not making those choices for you. And it turns out there is a correlation between people who have more control over their lives and more ability to make their own decisions, even if they're not great decisions, they're at least their own. They tend to be healthier, more independent, more well-adjusted, and safer. And sometimes that's counterintuitive to folks, because I often hear, well, I'm getting the guardianship paper to make my person safer. The paper doesn't make you safer. And in fact, when you don't have the ability to make choices about your own life, you are less able to recognize when something isn't right, when somebody may be going farther than they should with you. So, like I said, the law presumes people over 18 are competent, but culturally, there's a bias, has a name, it's called ableism. We look at people with disabilities and assume the opposite, that they are not competent to make their decisions. Everybody does, not everybody. People who interact with people with disabilities in a professional basis may have those biases. The healthcare settings, I hope I don't have any doctors on here, but there's been some recent research that says 85% of doctors believe people with disabilities have a lower quality of life. You know, this is very, very common that we see a disability and we presume that that difference means a lesser state of mind and of ability. Not true, by the way, not true. That is true. And a lot of times you may have experienced some of these things already. If you've been in a meeting and instead of talking to the person with the disability, the professional turns to you and starts having a conversation with you about the person in front of them. That is an example of ableism, right? They are looking to someone who they are more comfortable with, or who they think will do what they want, more likely, to solve their problem, instead of the person who they're supposed to be engaging with. And it's kind of scary out there, because there are a lot of professionals who are just looking for someone else to be the decider, and they don't necessarily understand the difference between whether you went to court and got a legal order and you are acting within your authority, or a power of attorney, or a supported decision-making agreement. And that's really tells you, that's very telling. When somebody doesn't ask, whether you're the guardian or to prove that you're the guardian or to show you what the parameters are of that guardianship order, it means they assume you're making all the decisions for the person. And that doesn't feel good if you're the person. Families are not immune. On the other side of the column, that you can kind of see that maybe there are families that where that lack of experience making decisions is because the family is not helping them practice, or they're not involving a person in decision making, or they're accepting the professional's deference to them and taking things over. But for people with disabilities who experience this all the time, it's a constant message and a constant barrage that maybe you aren't able to make your own decisions and somebody else should be making them for you. And again, as an able-bodied person myself, I would feel really bad if somebody said, you don't make any decisions about stuff that's important to you, like where to live, who you, whether or not you have a job, that kind of thing. And people with disabilities often experience a conditioning where they don't lose confidence in their own abilities to make decisions and start to see other people as speaking or deciding for them. Their preferences may not matter. I can't control my own life. I can't say no. I must comply. And it is no surprise that some of these statements on this chart are directly correlated to somebody who is on the path to accepting abuse. Okay. So you're in transition. Here's a list of all sorts of things that you're being asked to do right now. A lot of these decision points are occurring at the same time, and they're time sensitive. And you can feel like there's a lot of pressure and expectation. And plus, you've got other stuff going on too. It's not only this. So I just put this out here to kind of give us a breath in the presentation and let you know you are not alone. Some of the fears on this column, they are things that I have heard hundreds of times before. All the feelings you have are valid. And there's a lot being pushed onto family members in terms of, navigating this by yourself, even though there are other people around you. I don't know if that makes sense, but it can feel like everybody else is waiting for you to make a decision. And there may not be a lot of guidance for that. So we're going to spend some time on this slide. This is kind of a continuum of ways that people who need some support making decisions can get that support. And you'll notice an arrow on the bottom of the page here. Less limiting on one side, more limiting on others. What we're limiting is somebody's civil rights, the actual legal right to make your own decisions. That is what is on the continuum here. If you get to the purple column, you are having certain rights like the right to hunt, the right to fish, the right to vote, the right to decide where you live. Those kinds of rights are being taken away. And on the other side of the spectrum, there is no impact on your rights. So that's what that arrow means on the bottom. And we're going to start from least limiting to most. So in the green column here, release forms. Lots of you use these. Basically, it's a permission form to let somebody else do something. And they're so common, even for people with and without disabilities. We don't even think of them as necessarily a decision-making support, but they in fact can be, because oftentimes what is necessary is for another set of eyes to read something or interpret something or to have access to the same information. And you can give people permission to have that access, a parent or some other trusted person. You don't have to lose your civil rights to do that. You can just say, I'd like this person to be able to see this. And the professionals should say, let's sign a release form so that you formally acknowledge, and I'm not liable. A lot of these things are so that the provider doesn't get in trouble, right? So that you acknowledge you're giving permission for somebody else to do this. You might have to sign a release form every time or once, and it's good for a long time, but it is a decision-making support, and it can be very useful. Next, the kind of gold column here, supported decision-making agreements, which is what the back half of this presentation is going to be about. Again, there's no impact to the individual civil rights here. I have in Wisconsin because 25 states out of 50 now have supported decision-making as a law or an option. We were the 4th state to pass it. And lots of people took some language we made and added it to their laws. But the important part is the person makes their own decisions. They are always the decider. And they are in charge of their supported decision-making agreement. So they're choosing who they want to help and how they want that person to help them. And we'll get into that a little bit more later. The agreement is basically saying, here's my role as a supporter. Here's what I'm here to do. And the person is ultimately the decider. It's very flexible. It can be, strengthened if you need more support, or lessened if you need less support. Maybe you start with a supported decision-making agreement and you realize you need more support in an area. Maybe you start with a supported decision-making agreement, get a little bit of practice in the decision area that you are concerned about, and maybe you don't need the supported decision-making agreement after you get the practice. It's very flexible across the lifespan. The first blue column here, lighter blue, they kind of look similar, is conservatorship. Now, this is not a widely used option, but there are lots of people who are pretty good at making decisions about most things in their life, but not finances. And money management is important. So a conservatorship is, again, the person is not losing their civil rights. They do go to court and say, hey, judge, I would voluntarily like to appoint this person. I can see Liz. So Liz is going to be my example. I want Liz to be my conservator to manage my finances and property. Liz says, fine. And at some point, if I don't need Liz, or Liz has been bad and I don't want her as my conservator anymore because she's done something, or I don't need this support anymore, I can ask the court to terminate the conservatorship, and the court will do it unless you're legally incompetent. So this is a mechanism that if really money management is your issue, and the person voluntarily says, yes, I'd like help for that, there is a legal process through a court to have somebody be appointed a conservator, and that person can then manage the finances, and the person doesn't lose their ability to say, hey, I'd like something different, and they don't lose their civil rights on any of the other areas of their life. In the red column, powers of attorney, there are 2 kinds in Wisconsin: power of attorney for healthcare and power of attorney for finance. And these, again, are very flexible documents. They can be tailored. A lot of times people do go to an attorney to tailor them, but they're really intended to be kind of a moment in time support. So for powers of attorney, and I'll use healthcare because more people are familiar with that setting. I may be competent to make my own medical decisions, and perhaps something happens and Tami goes into a coma. Well, at the point Tami is in the coma, I am not competent to make medical decisions. And so my power of attorney is triggered. And the agent, that's what we call them, the agent who I've identified in advance is now temporarily able to make medical decisions on my behalf. And when I come out of my coma and regain competency, I'm making my medical decisions and the agent is not anymore because the power of attorney is no longer triggered. So you can set up a power of attorney where it goes on and off to be responsive to an emergency basis, and the person has made in advance a decision about who they want to act as their agent in the event the power of attorney is triggered. And then the power of attorney is activated, and when things change back to normal, it's deactivated. It kind of goes dormant. There's also a way to write powers of attorney where they're always on, called durable powers of attorney. And that can be another way to have support. It's almost like the person and the agent are always a designated decision maker. I see that more often with financial powers of attorney. Trust who you name as your durable power of attorney because they can spend out of your bank accounts, just a tip. But it can be done with healthcare powers of attorney as well. So again, only two big areas of life that they cover, finances and healthcare, but they're pretty important.
So Tami, before you go on to the next one, we do have a question in the chat. Are there costs? Could you just explain again, are there costs to getting a conservatorship and or a power of attorney, or there you don't have to, like, sometimes you have to file and you pay a filing fee for stuff. Is there any cost to conservatorship or powers of attorney?
No, and I'm going to go, well, let me be clear. No cost to release forms, no cost to supported decision-making agreements, not necessarily a cost to powers of attorney. There is an online form, kind of a generic form on the Department of Health Services website that people can just fill out. Many people choose, especially if they want a power of attorney that is tailored, choose to go to an attorney to talk about how they want to structure that. And if you go to an attorney, the attorney will expect to be paid. So that is a potential cost, but not necessarily, right? A conservatorship, there is a court process and there's probably a filing fee. And there's probably a hearing in which the judge says, okay. I don't have an idea how expensive that is, but I don't think it is as expensive as a guardianship where there's a lot more process and items that are needed in advance of the hearing. So I think there might be at least filing fees with a conservatorship. I don't know that for sure. I can ask my friend Polly, but since there is a court process, you do generally have to figure out, like, the court wants to make sure that time is covered. And often filing fees are a part of how they do that. Moving to representative payee. For some of your folks, if you are Social Security, SSI, or SSDI eligible, some of you may be filing paperwork to try and get your person into the Social Security system. The Social Security Administration does have an option called representative payee that can be designated. And the rep payee is somebody who receives the benefit checks on behalf of the person and is responsible for paying out that person's bills. Now, this is farther on the side of more restrictive because you do end up with if you control the purse strings, you end up with a lot of power by default. And certainly a rep payee can be a very functional thing where somebody's receiving benefits and making sure all the bills get paid and the balance goes to the person. It can also be used in a way that can be abusive, like, no, I'm not giving you your extra money, right? Because I don't think that you are making good spending decisions, or I want to keep it, or other things. So it is not taking away the person's civil rights to make decisions, but it does control the actual flow of cash that sometimes is important to following through on decisions. And then the last column we have here is guardianship. I'm going to pause and say that oftentimes, especially with people with intellectual and developmental disabilities, this is the place where professionals talk to families first. And they frequently say, have you gotten guardianship yet? Like it's just some administrative thing, in the pile of other administrative things that you're doing, applying for Medicaid, Social Security, all of those things. And it's not. And it's really important that you understand what it is before you make a decision about whether that is the best thing for your family. It might be, like, there are cases where guardianship is appropriate. It's often the first option people are referred to and presented as the only option, and it's often not the right option for a lot of individuals and a lot of families, because this is no longer just about the individual once we get to guardianship. So guardianship, you are petitioning the court to find the person legally incompetent to make their own decisions. And what you are asking the court to do is to take away some or all of that person's civil rights and transfer decision-making authority to another person called the guardian. Okay? That is what is happening here. Once a guardianship is in place, once a court has found somebody legally incompetent, rarely are those decisions reversed or revisited. So it is often a lifetime thing. And if you are an 18-year-old person who might live for multiple decades, that guardianship is unlikely to be looked at unless something really egregious happens when it comes to the court's attention. And we'll talk a little bit more about this, but the reality is that once a guardian is in place, the court is likely to appoint another guardian. They are not likely to revisit whether or not the person is still legally incompetent. There is a process in the law to restore rights. It's a good guardianship law, but in practice, it gets operationalized in a way that I would say reinforces ableism. Okay, so that's what you're doing. And yes, you do pay filing fees to go to court. You do have to pay to do this. You also are probably going to have to get a physician to fill out some forms that say, yeah, I think this person is not able to make decisions. Sometimes there's a psychologist report as well in advance. You do pay for that. There's a guardian ad litem that has to examine. It's a process, because what is actually happening is so serious. If you think about a guardianship being applied to yourself, almost none of us would volunteer to say, you know what I'd love for Tim to make all of my decisions about my life from now on. Like, none of us would willingly do that. Many times the proposed ward, because that's the legal term for the person who is now under a guardianship, may not even understand why they're going to court or what's happening. And a lot of times the court is not being particularly evaluative these hearings are over in 15 minutes. So if you want to go and get a guardianship and pay for it, you probably can. You know, you'll find some group of people that says, yep. And some of them will just look at the person, see a disability and think that's appropriate. But it doesn't come without work. So there are administrative tasks that are required of guardians that last the whole lifetime of the guardian. Under guardianship law, there's actually two different types. Guardian of the estate is really about finances, and guardian of the person is about everything else. Many times, the same person is appointed guardian of the state and guardian of the person, but it's important to know that there are actually two distinctions here, because it's possible that you could be appointed one or the other, right? And both have administrative requirements. Courts and counties may have additional requirements beyond what is in state law. So depending on where you live, you know, there may be more than what is in the statute. I'm not going to read these things, but I have heard every single one of these multiple times from people just like yourself or professionals. Maybe some of you have heard some of these things too, and none of them are correct. I think it's good to remember how many of these things are out there, because once you get the guardianship, look at that professionals column, that is going to be an experience that you have. And so it's not necessarily true. For many families, the other, you know, guardianship is a one point in time evaluation, and the limitations of that, I mean, it works well if the person that you're evaluating is never going to change. And there are people where that is the case, right? If you have a person who is perhaps in a persistent vegetative state, and there is absolutely no indication that anything will ever be different, then guardianship, you're evaluating that person in that moment of time, and they will continue to be the same. Yes, that works. If you are a person who is young and may continue to grow and develop brain or get additional experiences, maybe what you're like at 18 isn't going to be what you're like at 25 or 30 or 35 or 40. Then no matter what you do, you are held to the decision made at the time of guardianship as being what it is. And that is not the case for many people with intellectual and developmental disabilities. It's also a very poor tool to manage acute crisis. Oftentimes people with mental health issues, they will be put like Britney Spears is a good example. She had an acute mental health crisis at the moment in time the decision was made. Maybe guardianship was appropriate, and then it became not appropriate because she wasn't in the same state. But the law doesn't switch it on and off like a toggle switch. It's a switch on and it's forever on. So it is really a permanent thing. And when you think about what the court is being asked to do, they're being asked to evaluate whether or not somebody can legally make their own decisions. So if somebody comes back and says, hey, I'd like to change this, the judge has to kind of say, did we make a mistake the first time? Or what has changed since we thought you were incompetent that makes you competent now? And so from the ward's point of view, you are having to prove and advocate for your own competence in order to get a guardianship changed. And a lot of times what you want to get changed, it's always in a judge's hands. They may not do it. The court is always in control. They are the decider once a guardianship is in place. We've talked a little bit about what it feels like to not be able to make your own decisions. Many people with disabilities that I talk with will describe the guardian kind of creeping and making more and more decisions, because people get used to being the decider and then they want to decide more things. And there's not a lot of oversight with courts. So a guardian may be acting in the best faith, but they may start creeping outside of the authority they have in the guardianship order. And if you're the proposed ward, it's really hard to know what to do. And so lots of people describe this experience of an erosion of the rights they've retained, or the rights that you can't lose, because there are rights you can't lose as a person, even if you're under guardianship.
Tami, I just wanted to let you know you have about 5 minutes before hopefully we'll be able to switch. So I know where we are, so just wanted to let you know so that you can hit the most important stuff that you have.
Okay. So I'm going to move on to talk about supported decision-making. This is fundamentally different than guardianship. It assumes you can make your choices. It assumes that you can ask for help without having to lose your civil rights. And it's something that you and I do every day. Whenever we go out and say, I need to buy a new car. What kind of car should I buy? And we crowdsource for information amongst our friends. That is a form of supported decision-making. We consult experts in our lives. They provide information to us. We make our own decision. Whether it's about what immersion blender I buy, or who should I go to for help filing my taxes, name a decision, and we do this all the time. Well, why do we need supported decision-making then? Because cultural bias tells us that there's certain people who we don't think can make decisions, so we need a paper to validate that they actually can. Not everybody can use supported decision-making agreements, but people with intellectual and developmental disabilities can, as well as several other groups. You do not have to go to a doctor to prove that you can use these agreements. The law assumes if you say you can, you can. We trust you to self-identify if you belong in one of these groups. Supported decision-making doesn't restrict somebody's right to make decisions, including bad ones, and it doesn't give supporters new rights. Supporters do not make decisions on behalf of somebody else. They have specific roles that are defined by the supported decision-making agreement. And those roles are helping access information, really important. You know what a lot of older people use this for? They can't get through those darn telephone trees. They got hearing loss or something like that. The supporter on the phone helping navigate through those menus, that's a solution for them. They can help the person access information, understand the information. I don't know how many letters from state agencies you've received that are in plain language and clear. I've received 0. So if you have one, it's one more than me. It isn't always easy to understand important things that are sent to participants. A supporter can be designated to help somebody understand what those options are and pros and cons of those, just like your friend group would do, right? And I underestimated this, but one of the more important aspects for a lot of people of this law is assisting with communicating your decision to others. I have people I know who have cerebral palsy that impacts their speech. That's the only reason they want a supporter, is because they want somebody who knows and can interpret them correctly to convey information to a professional who doesn't understand them. That's what they want. You can't just take any information, but you can read these slides later. You can have multiple supported decision-making agreements because there are different people in your life that you would maybe trust to help you with certain kinds of decisions. The person that you want to have advice on taxes and the car or buying a car may not be the same person. Now, if you're under guardianship, that guardian has to be the responsible party for all things. So this is a way to think about, how do I build my network of support and identify different people who are able to and willing to contribute just a little bit in an area they're comfortable in. That's a big deal. You can change supported decision-making agreements, the person can, and the supporter can say, hey, I'm not able to provide this level of support anymore. This is a document that is to be revisited and revised at different points in time. And it can be done by either party. That's a healthy thing because people's needs change over time. So the other big piece, supported decision-making agreements can be used for any decision. Then it doesn't need to be healthcare or finances. We have special things for those. And yes, you can use powers of attorney or a conservatorship or a rep payee and release forms in combination with supported decision-making agreements. These are things that you can build a package of supports around a person that do a different thing. You can't do that with full guardianship. You can use a supported decision-making agreement on a limited guardianship in the areas where the person still retains their rights. But for the most part, you know, the most flexibility and the most options you have is not with a guardianship. So if you need help figuring out where to live, a supported decision-making agreement can do that. There's a standard form. It's on the DHS website. The most important thing, there's certain types of decisions included on the form. And the big reason why it's so flexible is there's an other category that you can fill in. Okay. A lot of people end up with a diverse network of folks in their lives. They're not always family members. And I say this with love for the families in the room, but at some point, all of us will not be here. And I think it's you know, when you're the guardian, the court will appoint another guardian. And it may not be somebody that even knows the person. It could be a corporate guardian. Supported decision-making agreements are designed so that the person is identifying who they want to be their supporter. And that may be a friend. It might be a neighbor. It might be a colleague. It might be somebody who knows them in a certain aspect of their life or more generally. And that's important because, you know, for a lot of older adults, their friends are the people who see them most often. And you know, this is a way for people who are not first order relatives to be able to provide some support. That's important. We've talked about how it can adjust to be stronger or lessen, especially as a person's needs change. You know, you don't need to go to guardianship if somebody's got dementia at age 55. At age 55, you could go to guardianship at age 85 when they really need it. You know, there's a way to extend the decision-making capacity over time, even if somebody's needs are changing and they need more help. Here's a link to the form. It's on the DHS website. You can fill it out. All you need to do to make it legal, the person fills it out. They identify a supporter. They identify what help they would like from that supporter. And then it needs to be signed by 2 witnesses over age 18 or a notary public. And you have a legal document that you should include with all your, you know, leave everywhere you go, right? And keep a list of where it is so you can go back if the document changes, just like you should do with a guardianship order or a power of attorney or any other kind of legal document. And you're good to go. No legal fees, no filing fees. Is a download on a website. We do have a toolkit available, and I always put the statute there just because, you know, other people recreationally read the statutes like myself. And with that, I'll take questions. Let me.
Right. As we move into that, if you could stop sharing for a moment, Tami, so I can get the next PowerPoint loaded up for you. For Liz, there is a question. Is there someone who can help families navigate and or write the supported decision-making agreements? Do you know if there's any group out there that is like working on that or doing that?
You know, we built the law to be as easy as possible. So there is no state staff that is waiting for your call to help you figure out how to put together an agreement. Our toolkit does have kind of a step-by-step guide for families to help you kind of figure out, okay, what is the support that I am looking for? Who are the people in my life that might be able to support me? And, you know, having tips on having the conversation about revisiting the agreement. There's also nobody that helps you with powers of attorney or guardianships either. just so we're clear, this is an area where there just isn't a lot of technical assistance. But we hope that, you know, between this presentation and our toolkit, that should put you on a pretty good pathway to filling out the agreement.
The one place that I would also point to that seemed to be very open to helping families and people with disabilities to figure out what forms say and fill out forms is you could check with your area independent living center. They are usually very open to trying to help you navigate things. So give me one, and I'm going to share the new presentation. Just 1 second. Tami, are you able to hang on in case people have questions after Liz is done? Or do you need to go?
Yes, and part of that is that I can't figure out how to get my mouse moving on my second screen. So yes.
Great, so you just stay there. That's fantastic.
Okay, thank you. Next slide, please, Tim. So one of the things I wanted to share was a little bit about how I can, as a transition coordinator, help with the process. I can assist the families with their referring to the ADRC at 17.5. We just had a presentation on that last week. I can help you coordinate with outside agencies with whom you may be collaborating. And I can help provide any needed documentation of disability as long as I have a signed release from you. And I can scan any needed documents for you and send to the person you're working with also if I have a signed release. And I can obtain information, pamphlets, documents, anything you might need to learn about the options. And I can help you plan through the post-secondary transition plan, the PTP that we talked about in our first week of Transition Talk Tuesdays, for the steps that you need to take in this process. And I can assist in answering questions and pointing you in the right direction as you're going down that path. Next slide, please. I did put some links in here. I know Tim shared some in the chat as well. So I wanted to talk just real briefly about self-determination and self-advocacy. These are really important assets to develop in our students to the best of their ability. And studies have shown that individuals who have higher levels of self-determination at high school exit tend to have more positive adult outcomes, better employment, better community participation. They're also safer. Self-determination can be developed at age and developmentally appropriate ways and is very individual to each student. So transition services and predictors, when you use a student-driven IEP process to allow students to demonstrate their own self-awareness, their own goal-setting, problem-solving, and self-advocacy, they can work on running parts of their meetings and have meaningful involvement. It's like a with us instead of to us philosophy. Collaborating with general education teachers to embed the choices that they have into the general curriculum and daily lessons and provide opportunities for students to practice their self-determination skills. And it's okay to try and not succeed. This builds our resilience and provides opportunities for the staff to support the student to gain these skills over time. And we want to ensure all students, including those with significant disability or support needs, have a functional communication system to engage in choice making, problem solving, and goal setting. They're taking initiative to reach their goals and accepting the consequences for their actions. Sometimes we're doing that in different ways using different alternative communication methods as well. So how do we go about developing our self-determination and our self-advocacy? A lot of it's trial and error, but we talk about your job and other jobs. Ask questions of the school counselors, their case managers, the teachers, community members, visit places, do some checklists, begin a portfolio with your child. I have some portfolios I'd be happy to share. Encourage your child's active participation in IEPs. It's so much more powerful when the students are the ones that are driving the IEP, when they're the ones saying, nope, don't want to do that, or yep, I want to do that. It's their life, it's their education, it's their future. We want them to be able to say yes or no, or give ideas and thoughts as well. Assist them in expressing their thoughts or ideas and allowing them the opportunity to answer questions first. There's lots of times where I'm talking to a kid in an IEP meeting or something like that, and the parent or somebody else answers for them. So we want to be sure that we're giving them the chance to say things and answer questions. So become informed, have campus visits, do some online searches, and have the student make their own doctor appointments, pack their own lunch, do their own laundry, do things for themselves as much as possible. Have them talk on the phone. It's still a skill that's really important. Doctors' offices don't typically text or Snapchat or do Instagram, neither do people in post-secondary. So talking on the phone and using email are really important. And have them check on their grades and their progress reports as well. A portfolio is, I had a question in the chat, a portfolio is something that allows you to keep all of your things in one place, whether it's your IEPs, your reports, your experiences for work, different documents that you might need. And I can show you what one of those looks like if you'd like. Next slide, please.
No problem. And Liz, I just need, you're doing great. And I know we're running out of time, but if you could just go a little bit slower.
I will try. Thank you. So tips for self-advocacy: know and understand your rights and responsibilities. Learn all you can about your disability, your needs, your strengths, your areas of difficulty. Know what your accommodations are and why you use them and why you need them. Know how to effectively communicate your needs and preferences. Sometimes that's verbally, visually, through the use of switches or other communication avenues. And find out who the key people are and how to contact them if necessary. Be willing to ask questions when something is unclear or you need clarification. That's why we're there. It's to help you understand, to help you know, and give you the power to make some choices. It's not always easy. It sounds easy sometimes, but it's not. We want things to begin with your parents and guardians, but we want you to take that ownership as well. Explain to your child the reasons for the IEP, why the IEP is helping, and what it means for their success in school. Your level of comfort leads the way. Sometimes kids think that there's nothing, I don't have an IEP, or these accommodations or things that I'm getting, everybody gets, and that's not necessarily true. So we want to make sure that you understand what your IEP is and the reason for it. You want to contact your case manager if you want to discuss things more further with them. And we want you to model how to ask questions so your child sees that this is okay. You don't want to be passive. You want to have your questions answered. We want you to understand. So we want you to learn all you can about your disability, your needs, your strengths, and your areas of need. Do you know why you or your child is in special education? Do you know what their label or category means? We throw around a lot of acronyms in special education, and it can be very confusing. So do you know why they're in it and what that category is? Do you understand the components of the IEP and what's required by law? It's difficult for us as parents and adults, so it can be very difficult for a child or a student to understand. So learn along with your child, learn along with us, and we'll explain things as developmentally appropriately as we can. We want the student to be involved in the IEP as early as possible. I've had elementary kids introduce people at their IEP meeting. They can talk about themselves a little bit, what they like, what they hope for their future. It can be for a few minutes, portions of the IEP. It doesn't have to be the whole thing, but whatever they can do to be involved is super important. Know what accommodations you need and why you need them. Accommodations level the playing field. They work with the student to facilitate their understanding and to have them practice explaining what their accommodations are. When they do go on to college, the college doesn't want to hear from me. They don't want to hear from parents. They want the student to be able to advocate for their accommodations. I was taking a student down to college one day for a transition meeting, and she had a math disability, but she was asking for a reader on her tests, and she was asking for extended time. And I said, so now how are you going to ask for that? Because you don't have a reading disability, right? And so we talked and problem solved, how to do that. And she went in and she advocated very successfully for those accommodations. So they need to understand what they need and how to advocate for it. Those responsibilities fall on their shoulders as they move on. And it's important to practice and fail and try again. It's the key to it becoming a permanent skill. So how does self-advocacy and self-determination relate to today's topic? As you may need to explore guardianship and other means of support, having the skills to be an active participant helps navigate this process as much as possible. Where your young adult is right now is not where they might be in 5 years' time. Developing these skills helps them to live as independent a life as possible and allows them to more fully participate in the life they dream to have. It helps them become active participants in the process to the best of their ability, and it sets themselves up for the greatest success in living as independently as they're able. And it includes them in the process and helps them understand themselves and who they are as individuals. And it gives them that sense of empowerment. I can and I will. It's nothing about us without us. So there's some resources I shared here for some student-led IEPs. Many of our case managers are having students lead portions of their IEP right now. And if you want to look at some of those resources, please feel free to. Next slide, please. So success is totally individually driven by the individuals and what they need and what they desire. Next slide. So we finished our third Transition Talk Tuesday. Our next one will be next week with Tim, who will be doing healthcare for people with disabilities. And then we have Working Well on Social Security, the Ticket to Work, Past Program and Benefits Analysis. And then we'll have our Sauk Prairie Beyond 18 Programs and Employment. And we're hoping to have some a guest speaker to that one as well. And here's the links again for signing up for the next Transition Talk Tuesdays. And then there's my contact information. And thank you so much for Tim and our interpreters and Tami. And if we have any questions, please feel free to ask them at this time. And I see Tim included a link for a very short survey if you have time to do that. Any questions for Tami?
Yep. Feel free to unmute. We will see you on mute, or you can put your questions into the chat and we will repeat them for you. We appreciate your time and your patience.
Okay.
And we can also acknowledge that this has been a lot of information. So thank you all very much. I'm just going to close this out and then I'll stop the recording. If you have questions that you didn't want on the recording, please just hang tight and we'll just remain here. But thank you so much for being here.
Thanks, everybody.